And I think in the past year, probably in the past 19 years, the most contentious issue has been the solid waste ordinances. And so a lot of people want to know is, Mr. Rich, I mean, who wrote those ordinances and what was your responsibility in that?
I wrote those ordinances at the direction and request of the county commissioners. I know my opponent wants to blame me for that, but I was requested by the commissioners to write a solid waste ordinance. My office reviewed solid waste ordinances from Jackson County, Deschutes County, and Douglas County, and the measure that was actually presented and went forward with the county commissioners was virtually identical to what they have in Jackson County. There's also been questions about the ballot title. The district attorney certifies ballot titles. The district attorney, which probably won't be a surprise to any of you, primarily deals with criminal law. So we do everything we can to help the district attorney with that task. The ballot title law and the way those ballot titles have to be written is very, very specific. You get a 10-word caption, you get a 20-word question, and you get 175 words to explain a multiple-page document. That's not easy. But we did the best we could. The DA certified that. The board, by the way, adopted those ordinances with a split decision. So when looking at the ordinances, one of the commissioners decided, nah, I don't like this, and the other two did. Now, frankly, the matter was passed by the commissioners and referred to the people, and the people said, we don't want it, and that's fine with me. The people get to decide these things in Oregon by referendum, and that's exactly what happened here. Thank you.
Mr. Hicks, how would you have handled that same situation differently?
The solid waste nuisance ordinances may have been, and apparently were, requested, written, and initially passed by the people who are in the government, but they're absolutely not in people's interests. So the people demonstrated that by repealing them on a 4-to-1 margin, pardon me, in the special election last fall, which cost apparently $40,000, give or take, extra, tax dollars extra to our county government. The ordinances were draconian, I say. The ordinances included the creation of a new crime, which would have created a misdemeanor punishable by 1 year in jail for failure to obey the hearings officer. The ordinances allowed for warrantless searches of the property at issue by the hearings officer. In the collection of evidence, a certain property would have been subject to twice its fair market value if certain conditions were met in terms of the fine. Twice in the ordinances, what I saw was that the fine must have been paid prior to a trial. If a trial is requested, the fine must be paid prior, and unless it's waived by the hearings officer or the court, and the rules of evidence would not have applied to such a proceeding. All these things were not in the ballot title. These things were not in the ballot title, and these things were in the ordinances. They were draconian, they were not in the interest of the people, and this is where we do see the philosophical difference here between the two candidates. So, in my philosophy, that sort of thing is by no means in line with what the people of this community want or deserve. I would not have written it, I would have handled it very, very differently.
Well, I do, because the fact of the matter is the commissioners make those policy decisions. The commissioners are the folks that you have elected to make that call. If one of the agents, whether it's the treasurer or the assessor, says, I don't like what the commissioners want to do there and I'm not going to do it, I don't know how you would function as a government entity. I don't think the people have elected me or whoever they decide to elect to be a override or a checkmate on commissioner action. That's not my job. That's not what you're electing me to do. And if Wally Hicks is the next commissioner, he will not be able to do that either and function as he should, in my opinion. The other issue is that if you want to have a hearing on any kind of a matter, that was provided for. So regarding how Mr. Hicks would have done things differently, I've yet to hear an explanation of what you would do when the commissioners ask you to write them an ordinance, and you present an ordinance, and you explain, this is what they are doing over in Jackson County, and they said, that's good. One of them said, no, I don't like that. The other two said, yeah, let's do that. So that was my response to that.
Yeah, in plain terms, I wouldn't have written that. I wouldn't have written it. Not in the people's interest. This is what's playing out here is that philosophical difference between who County Legal Counsel works for. Uniquely in Josephine County, you have the opportunity to elect the County Legal Counsel. And that means that the people of Josephine County years ago decided that they want the legal counsel to work directly for them and ultimately for them. And so the legal counsel does have the authority by the people to decline tasks. The legal counsel can do work for the commissioners, but ultimately does not work for them. Legal counsel works for the people. And so, and I don't mean the people, by the way, in the government already. I mean the people outside the government. And so this is healthy. This is a philosophical decision that I'm urging the people to make. I say the legal counsel works for the people, no one else.